So one of the areas of entrapment that I've not talked about for a while is the concept of predisposition to commit a crime. In other words, there's some evidence that you had predisposition to commit a crime. Let's say, for example, in a sex crime, you are talking to a child and you are talking about sex and you agree to meet and you talk about all the sexual things you're going to do and you show up and it's not a child, it's an actual adult, either a vigilante or a police officer. And I'm not suggesting that the two are the same at all, but that would indicate predisposition, certainly. But what if you are not talking about sex? Sex never comes up. You show up and there's nothing in your car, in your vehicle when they arrest you, and you have been talking about proactive stances protecting somebody from what has happened in their life or what you have reason to believe might be happening to them, whether it be trafficking or some kind of child abuse or neglect or something of that sort. That would be an example of not predisposition. And a similar discussion came up recently in the Ninth Circuit case, the appeal case of U.S. v. Curry, where in this case, Mr. Curry, who was serving time in prison already for a sex crime against a child, was up on a companion case. And the issue was, among other issues involving entrapment-related designs, that the state were arguing were not entrapment, and the defense, of course, were arguing was entrapment. The issue of predisposition comes up as one of those elements. And the judges there, question the state, as well as the defense, but mostly the state, the appellee versus the appellant. The defendant, of course, is the appellant. He's the one who had asked the court for review. And the judges asked this person, hey, tell us about what predisposition. And if you listen very carefully to it, you can hear the lawyer for the state talking very slickly, very quickly, and skipping over certain words or characterizing things by slipping in a word in there. And one of the judges, the elderly gentleman to the left, if you're watching the video, he's on the far left, he would not let the state get away with any of those things. He would not allow a specific characterization that was not clearly demonstrated in the law. And this is a case, again, where Mr. Curry was serving time for something he had already done. And they were not willing to say, well, if he already did it here, he must obviously be doing it every other time you accuse him of doing it. That, to me, is a good review of the case, where a judge is really looking and asking good questions. So the issue of predisposition means in many cases you have to take some affirmative step. Well, in Virginia here, some affirmative step in my case was showing up. In other people's cases, it's showing up. Sometimes it's driving in that general direction, turning around saying, this doesn't look right, and going home and being picked up 4 years later or 4 weeks later. And the issue really is something that is handled by case, by judge versus judge. And they all have a different idea of what predisposition and taking that affirmative step is. This is why when somebody is convicted, you don't necessarily assume they're guilty.